Welcome to our company law 2. We are continuing with corporate finance. So tonight we shall be exploring shares, the first part of shares. So we try and understand the meaning of shares, the legal nature, and the incidence of shares. And we look at certain basic concepts associated with shares, the no par value concept, the issue of shares, payment for shares, and evidence of having shares, share certificates, and then the concept of dematerialization. And we also look at some canons or typology, classes, or kinds of shares. So those are the matters we hope to explore in this particular lecture. So to start with, we need to understand what shares are or what is a share. And as we have indicated, company law is heavily a statutorily based law. That is to say that the bulk of the law is located in a major statute known as the Companies Act 2019, Act 992, and of course, the Corporate Insolvency Restructuring Act and other related legislation like the banks and other special depositing taking legislation and so on. Now, what that means is that we must always start from the statute to find out, does the statute say anything regarding the particular concept which we are dealing with? If it does, what does it say? What does it mean? How do we apply what the statute is saying? And are there any cases by the law courts which have pronounced on the meaning or the application or illustration of these statutory provisions? So that is the proper way in which we approach company law in Ghana. And of course, by necessary implication or mutatis mutandis, company law in any other jurisdiction, as it were. So, on that note, I invite you to come with me to the interpretation session, which is the first schedule. If you look at section 383, that is the definition sessions encapsulated in the first schedule. So you can just jump to page 301 of the legislation. If you go to page 301, let me see if we get there quickly and then we come back. 301. Good. So if you go to page 301, as you can see, the first schedule, making reference back to section 383. If you go to section 383, it says that various, let me just show you in a minute. So look at 383 here. Interpretation section 383. In this act, unless the context otherwise requires, the expression defined in the first schedule have the meanings assigned to them in that schedule. So that is what section 383 is saying, that certain words, certain expressions and phrases are supposed to be understood in the sense which have been stated in the first schedule, except, of course, where the particular context, the particular place in which we're dealing with a particular provision suggests otherwise. Otherwise, that is the meaning. So therefore, let's go to the first schedule to find out what the law says about the meaning of a share. So first schedule definitions. They're like in alphabetical, just a bit like a dictionary. So they're in alphabetical order. So we jump to the X side, shares, quickly. Yeah, so we come here, you notice that shares are here. So according to the first schedule, reference section 3.3, shares mean the interests of members of a body corporate who are entitled to share in the capital or income of the body corporate. So this is the meaning of shares. So when we say shares within the context of our company law, it simply refers to the interest, the stake, which a member of a body corporate, that is an incorporated company, as it were, has in the capital of the company or the income made by that body corporate. So the stake, the interest, the quantum of interest you have in that is what we mean by shares. So let us understand that clearly. So therefore, shares go with membership. As you can see, you must be a member, you have shares, and then the shares, what does it mean? That is to say that you have a stake in the capital. In our previous class, we discussed various ramifications of capital of the company, or the income that we have generated by the body corporate. The stake that you have in that is your share. We'll go back to section 51 to learn more about the legal nature of shares. In page 51, I mean, not section 51. Yeah, so we come back to section 42. So section 32, we are told the legal nature of shares. And what is it? The shares of a member in the company are movable property. So movable property implies that it is not immovable. It is not, if you like, a rare property. It is a personality. It is a shows in action as opposed to a shows in possession. In other words, the shares you have in a company is a stake, is a quantum of interest which you have in the capital or the income of that company or the body corporate. And that is property. It has a proprietary character. But what type of property is shares? It is not the same as landed property. If it's a landed property, then we say that it is an immovable property, or if you like, a rare estate. But shares are not immovable property. And that is why section 42(1) is telling us that the shares of a member are movable property. And what does that mean? That is to say that, as I've indicated, it is not a shows in possession. You do not enjoy your rights by, for example, taking possession of the particular thing. Just as you can have enter into possession on, let's say, like a land. You cannot enter into possession of a company simple because you have a shares in that company. It doesn't work that way. You enjoy the bundle of rights by a legal action to enforce it. You sue to enforce it, assuming your rights have been violated or your rights have been infringed as a shareholder. And that is why we say that it is a shows in action. So let us keep that in mind. So shows in action. So look at the spelling. Shows in action. So that is what the share really is. It's not a shows in possession. So let's keep that in mind. Again, shares can also be, being a property. You can will it. You can give it as a gift. You can transfer it in appropriate situation as the case may be, because it is a property. You can use it as a security to raise a loan or to do any other transaction because it is a property. Another point to note is that, yes, shares refers to the stake or the quantum of interest you have in the capital or income of a body corporate. The returns which you get by having shares, in other words, the financial benefit which you get from being a shareholder, is when profit is made in the company in accordance with established principles and procedures. Portion or the entirety of the profit, as it were, is declared as being available to be distributed as dividends to shareholders in proportion to the number of shares that they have. So the returns you get from being a shareholder are dividends when they have been declared by the company. You cannot just on your own say that the company is running, I have shares, so give me some of the money. No, it doesn't work that way. Profits must be made, and according to established statutory formula and other procedures, portion of the profit is declared as being now available to be distributed to those who are shareholders by way of dividends. That way you enjoy. So that is how it is. Let's keep that in mind. Now, having understood the legal nature of shares, we also need to note that in terms of section 42, subsection 2 of Act 992, the number of shares in a company and the rights and liabilities attaching to the shares are dependent on the terms of issue. And this is quite important for us to appreciate. That is to say that, first and foremost, shares may carry different bundle of rights, may carry different liabilities or responsibilities, as it were. So let's keep in mind. Yes, 2 or 3 people may have shares, but the shares that they have may actually confer different benefits and not the same benefits. So that is very important, because section 42 is saying that the rights and liabilities associated or attached to any particular share is very much dependent upon the terms of issue. That is to say that when the shares are being given out, that is when they are being issued, the company will use its appropriate procedures to determine the rights which are to be enjoyed by the person being given the shares, the shareholder, or the liabilities, the duties, which are to be borne by the shareholder. And that is why I have made the point that not all shares carry, if you like, the same rights and liabilities. Again, the number of shares, the total number of shares in the company are also determined by the company, of course. At the time that the company is being registered, being a company limited by shares, as part of the registration procedure, they will have to indicate the total number of authorized shares. The fact that you have registered a certain number of shares as authorized shares does not mean that you are immediately going to issue out all those shares. No. It only means the maximum number of shares which your company can ever issue. And on this point, there is a development in Ashanti region with respect to number of rural banks. You know, the rural banks, because the Bank of Ghana was quite lax in terms of its regulation for many years until recently. A lot of practices were going on, including the fact that they'll be selling shares without paying attention to what the regulations or now called constitution of the company, for example, permit them to issue. So much so that they will end up selling more shares than they actually have available according to their constitution and registered documents. And in the course of time, some shareholders become enlightened and they take up an issue that certain number of shares which have been issued in excess of the maximum number of shares as per the registered constitutional documents should be declared null and void and should not have any effect in diluting the rights of shareholders whose shares are within the allowable maximum limit of shares that could be issued. And that really presented an unpleasant scenario, which made its way to courts. Yeah, so just to let us appreciate the fact that the number of shares that a company may have are not ad infinitum. They are actually prescribed according to the registration document. So let us keep that in mind. Now we'll come back to the point that different rights attached to shares when we are discussing types or the classes of shares later on. Now we will discuss the concept of no par value shares. The concept of no par value shares. Now, what does that mean? What does it mean to say that shares have no par value? Well, to start with, we will probably go back to the concept of nominal value and then share premium before we actually discuss what it means to say that shares under our company law regime have no par value. So if you go back to old company law, including that which pertains in England, we have what we call the nominal. Can you see what I'm writing? Can somebody confirm? Can raise up your hand or you just write in the chat. Now you see what I'm writing. Yes, Juliet. Okay, all right. Nathaniel. Yes.
It's nominal value. Nominal value.
All right, thank you. And then share premium. Good. So we start from nominal value and share premium before we work our way back to section 43 to discuss par value. So first and foremost, when we say nominal value, what does that mean? Well, nominal value in English company law meant the minimum value that a company must demand to receive as contributed capital in exchange for the shares. In other words, when the company was giving out shares, if it was not going to receive any money in return for the shares being given out, at least a certain minimum amount should be made. And that was like, if you like, the nominal value, or what you call like the face value. So, for example, if a company has only one class of members and the nominal value of each shares is, let's say, 50 pesos, and I undertake to contribute 5,000 Ghana cedis worth of capital to the company. In terms of the nominal value, what it means is that I cannot expect to be allotted or to be given more than 10,000 of its shares. Yeah, so that is the nominal value. Then we also have the share premium. The share premium refers to the price in excess of the nominal value at which the share is allotted. So if the nominal value or the face value is 50 pesos, right? And if the company is able to get, let's say that the shares issued at 2 cedis, the shares will be said to have been issued at the premium because the price at which it was actually allotted or given out is in excess of the face value, the nominal value. So let's get that right. So the nominal value is the minimum face value, as it were. And then the share premium is where the shares are actually sold or allotted at a price in excess or higher than the face value. Now, where the shares are given out at a price lower than the minimum value, then we say that it has been issued at a discount, as it were. So let's have that general understanding at the back of our mind. And now let's come to what we call the concept of no par value. So if you look at section 42, section 43, we are told that the shares created or issued under this act are shares of no par value. They are shares of no par value. What does it mean to say that the shares are of no par value? Well, the concept of no par value simply means that no company is required to have a certain face value, a certain nominal value assigned to the shares, and say that this company is, for example, registered with 100,000 shares at 1 CD per share, and that is enshrined in its constitution. Now, if that were to be the case, we say that we have what we call the par value share regime. But in our company law, we have moved away from what used to be the case in English company law, where they practice the par value concept in terms of what I explained with respect to the nominal value and then the share premium. But if we look at our jurisdiction, starting from 1963, when we had the Companies Code at 179, which is repealed and substituted by the Act 992, Professor Agawa will make the point that if you look at actual practices of company, when it comes to share dealing, in reality, shares are not always issued according to the face value, and that the value of shares vary, and it is also dependent upon interactions of demand and supply and other market forces, as we know. So therefore, at every point in time, if you want to know the true value of the shares of the company, it is not realistic just to say that this company was registered with less than 100,000 shares at 1 CD per share. And for that matter, if 50,000 shares have been issued, then the value of the shares of the company altogether is about 50,000. No, that will be an exercise in artificiality and superficiality. Rather, you need to determine the net worth of the company. You've adjusted the assets and liabilities and all that, and then you use the number of issued shares as the divisor to divide it, and then to know the actual value of each share. And that may not necessarily coincide with the so-called pre-stipulated face or nominal value. And that is why Section 43 has said that the shares created or issued under this act are shares of no par value. So let us keep that in mind. And what that also means is that it may well be that you got the same company. Let's say you got your shares issued in 2015, okay? In 2015, you probably got one share at 2 cedis, per share. Let's say I'm getting shares in the same company in 2025, and I'm probably getting one share at 5 cedis per share. We are shareholders. When dividends are declared, the dividends will be reckoned according to the number of shares that we have. We're not going to say that because you bought your shares at 5 cedis per share, we are going to give you more dividends. No, as against the one who bought it as a 1 cedi per share in 2015. It doesn't work that way. So that is the practicality of having no par value shares. Because if you have like the par value shares, it creates accounting inconveniences, and also it doesn't give like a true picture of the rare value of the shares of the company at every point in time. Now we would like to discuss issue of shares. Issue of shares. What does it mean to issue shares? Now, before we discuss the concept of issue of share, it is worth explaining the relationship between what you call the issue and allotment of shares. Issue and allotment of shares. So to start with, the process by which members take shares from a company is called issuing the shares. So the process by which shares are given out is what we call like the issuing the shares. A previously unissued share is said to be allotted when a person acquires unconditional right to be entered in the register of members in respect of the share. But I must say that if you look at our Companies Act 2019, unlike the Companies Act of Britain, where they have like the fine distinction of allotment and then the issue of shares. If you look closely, we don't have that strict distinction. So let us keep that in mind. So as we read the textbook, if you come across allotment and then issue of shares, you shouldn't get confused as I am explaining, as it were. Now, if you look at, let's say, the British companies legislation, their lawmakers will make the point that where shares have not previously been issued, okay, they are said to be allotted when a person has acquired unconditional right to be entered in the register of members in respect of the share, where the person has done all that is necessary, and his name must necessarily be entered in the register of members as having acquired the shares. That is what we call the allotment, and he will be called the allottee of the share, as it were. Now, if you look at the current changes which have been made in, let's say, the British Companies Act, the term allotment was usually used to refer to a decision by directors to issue shares to particular applicants. So that was the meaning of allotment for a long time. When the directors have decided, okay, are going to give shares to X, so that decision was called the allotment, and then becomes, if you like, the allottee, as it were. Now, that decision will not necessarily give the applicant an unconditional right to be registered in the register of members, because it might be conditional on the applicant paying a certain amount of money for the shares, as it were. But if you look at the new law now, shares are not regarded as allotted until such conditions are fulfilled. That is to say that under current English company law, the concept of allotment simply means that a prospective shareholder called the allottee has done all that is necessary for his name to be entered in the register of members as a shareholder. So that is allotment. But as I indicated, in our own jurisdiction, if you look at the law, particularly section 44, it's quite simple. It doesn't tries to draw any fine distinction between issue and allotment. And all that it talks about is issue of shares. And what does it say? So section 44(1) says that subject to the registered constitution of a company, different classes of shares may be issued, that is, may be given out in a company at the times and for the consideration that the company shall determine and shall be paid for at the times that are agreed between the member and the company. Now, this provision has a number of important points to analyze. First and foremost, section 44 recognizes and also affirms what we've already observed when we were discussing section 42 subsection 2, that the rights and liabilities attached to a shares are dependent upon the terms of issue. So section 44(1) is reinforcing that different classes of shares may be issued. Different classes in the sense that shares may have different bundle of rights or liabilities or responsibility associated, and that makes it a different class. So section 44 is recognizing that. And again, the times when the shares will be issued is something which will be determined by the constitution of the company, or at the time agreed upon between the member and the company. So the point to note is that the whole exercise of giving out shares, issuing shares, is contractual. It's an agreement between the prospective shareholder or the member and the company. And therefore, how many shares are going to be given will be determined within the context of that agreement. When exactly are the shares supposed to be given out, and how much consideration, how much money or value should the shareholder be given for, should the shareholder give to the company for the shares which are being given out, will also be worked out in the agreement. So let us keep that in mind. And again, when the agreed consideration is supposed to be paid, will all be determined in the agreement. There's a case called Adesheman Gardens, Asibe versus Adesheman Gardens. I made you read it last semester. And if you remember the facts of the Asibe versus the Adesheman Gardens, there was, among other things, an issue as to whether a person who has not fully paid for his shares, is that person still treated as a shareholder, or he's not a shareholder or member because he's not fully paid for, he's not a fully paid up member. And that comes back to the point we are discussing as to whether the shares have been paid according to the time agreed to be paid, or the time for payment had not arrived. So the timing for payment, they are all matters of the contracts which was made between the company and the member. So please, I'd like you to read Adesheman Gardens Limited against Asibe. Adesheman Gardens, let me write it. You know it already, I mentioned it last semester. Adesheman Gardens Limited. against Asibe. Against Asibe. So take note of that. And then the citation is 2003, 2004, Supreme Court of Ghana Law Report. Page 1016. Sorry, page 1016. Yes. Read that. So, for example, if you look at that case, I'm just taking a portion of the head note. Head note 2, quote, the respondent, by subscribing to the regulation of the company, contracted to pay in consideration of his 200,000 shares, an amount of 200,000 old Ghana cedis. Since there was no other agreement under which the respondent agreed to pay any other amount in consideration for his said shares, that is the extent of the liability the respondent undertook when he subscribed to the regulation. This is an agreement under seal and is binding not only as between the respondent and the company, but also between the respondent and other members, as well as between them and officers of the company. Then it will continue. The value of the company's fixed assets is irrelevant to the settlement of the consideration payable by the respondent or any other subscribers, for that matter, for their shares in the company, since it was fixed in the regulation and there was no evidence that any part of the shares were to be paid otherwise than in cash. The value of such assets will be relevant only if the company were to issue additional shares to the existing members or new shareholders. In that event, such value may be taken into account to determine the price at which such new shares will be issued. However, in view of the fact that all the authorized shares stipulated in Regulation 7 were fully subscribed upon incorporation, the company cannot even do this without first altering its regulation in accordance with blah, blah, blah. Now, then it continues. Since on the evidence, 1, the company's stated capital continue to be 1 million new Ghana cedis. 2, the shares of the company were fully subscribed from inception. 3, there is no evidence that there was any increase in the authorized shares of the company, in spite of which the respondent agreed to take additional shares. There was no legal or justifiable basis whatsoever for the amounts demanded by the appellant as payment for 20% shares purportedly offered to the respondent. So, peculiar. There is an amount of 47 million old Ghana cedis the company purported to demand from the respondent as consideration payable for his shares. According to Exhibit R, the appellant arrived at this amount by apportioning the value of the fixed asset, which was stated in the audited accounts Exhibit B to be 237 million amongst the shareholders according to the subscribed shares. This is not a legal mode for ascertaining shareholder liability on unpaid shares, which is solely referable to the subscription to the regulation or the agreement, with my emphasis, under which shares are issued, unquote. So, Justice Sophia Kufu actually then was, who wrote for the decision of the Supreme Court, was teaching a very important lesson that First and foremost, as section 44, 1 is telling us that how much is supposed to pay for shares are all matters which are determined by either the constitution of the company or the agreement under which the shares were issued. So therefore, if they have the agreement that a certain amount of money is supposed to be paid and a portion of it remains unpaid, if in future you need to demand that it is what the agreement has stipulated as being owed, which will have to be paid, and not any attempt to try and find out. Now, if we take the current value of the company in terms of the assets against liabilities, what is the prevailing value of shares? And that should be used to determine the arrears, which have not been paid. No, that is wrong. So Adishman against Asibi is saying that once the consideration or the price has been determined at the time of issue, either by the registered constitutionalist as at the time of incorporation of the company or subsequent to the incorporation of the company and the agreement, it is the term so agreed, which will be the governing framework and not any other mode for determining how much or liability that should be borne by way of the unpaid shares. So let's keep that in mind. Then again, section 44 2 tells us that on the winding up of the company, every past and present shareholder of the company is liable to contribute to the assets of the company to the extent referred to in section 40 when we were discussing membership last semester. If you remember, we talk about liabilities of members, and depending upon whether it's a company limited by shares or not limited by shares, that is what we discuss. Now, for now, we are interested mainly in the company limited by shares. And the position of the law in terms of section 44(2) is that if the company is winding up, that is, if the company is closing down, the company is being dissolved, is closing down, and there are debts to be paid. If you are a shareholder, if you have fully paid for the shares which were issued to you, then you have no trouble as far as the winding up is concerned. Nobody can ask you to come and pay anything extra. All that you stand to lose is the amount of money you paid for the shares that have been issued to you. On the other hand, where shares have been issued to you, as section 44, subsection 1 contemplates that maybe under the agreement under which the shares were issued to you, you are not required to have immediately fully paid for all, and maybe only a fraction or percentage was supposed to be paid upfront, and the remaining value to be paid for in future upon a call or demand being made by the company. And let's suppose that no such call or demand was made and the company is winding up and the books of the company are going into, and you notice that there are debts and liabilities which need to be settled. Now, in the case of the shareholder who has not fully paid for the shares issued, you will be called upon to come and pay the unpaid value, the outstanding value in respect of the shares which were issued to you. Once you pay that, if there are even still debts to be settled by the company, nobody can ask you to pay any amount. And again, when you are being called upon to come and pay the unpaid value, as the Supreme Court has taught in Adeshiman Gardens against Asibe, you are going to pay the amount of money which if the company had wanted you to pay for everything at the time that the shares were issued, but which may be under the agreement of the company, they say, I don't pay or you demand the rest later on. It is that amount you are going to pay and not necessarily the prevailing value of the shares of the company, considered in the light of adjusted assets and liabilities, as the case may be. So let us keep that in mind. Now we come to section 45, payment of shares. Payment of shares. First and foremost, we should appreciate, as we noted from our previous class, the maiden session on corporate finance, that when shares are issued by the company, it is not for fun. Shares are not just given for the fun of giving out shares. On the other hand, issuing shares remain a very important means of raising capital for the company. And that has an important implication. And what implication is that? That is to say that anytime shares are issued, it should bring positive value. It should bring some value to the company in terms of its capital. It should bring inflows, some value, either direct or indirect, as the case may be. And that is the foundation for section 45(1), that, quote, except on capitalization issue pursuant to subsection 1 of section 77, shares shall not be issued otherwise than for valuable consideration, paid or payable to the company, and unless otherwise agreed, shares shall be paid for in cash. So this is a very important provision. But to start with, I presume or take for granted that in view of the lectures we had last week regarding the introduction to corporate finance, when I say capitalization issue, you will understand what it is. Who will explain capitalization issue for us before I move on with my discussion? Capitalization issue. Somebody says you cannot hear anything. Evans Blay, are you saying you cannot hear anything? Really? Okay, we have a hand up. Juliet, your hand is up. Okay. Yeah, so explain capitalization issue for us.
Good evening, my lord.
Good evening, Juliet.
Please, capitalization is also known as bonus shares. It is shares given to existing shareholders, which amounts to the dividend the shareholder is entitled to. It means instead of paying dividend to the shareholder, additional shares amounting to the dividend will be issued to the shareholder.
Okay, all right. Thank you very much. I think that that is a point on explanation. Yeah, so we noted that capitalization issue, also known as bonus issue, is where dividends are supposed to be paid. Instead of distributing dividends, is plowed back into the company, and existing shareholders who are entitled to be given the dividends are given more shares in proportion to the amount of dividends which will have been paid to them. So that is a capitalization issue. And as the concept indicates, because the shareholders were supposed to have been paid dividend, which is money to them, when more shares are issued in proportion to their dividends, they don't have to pay any money to the company because already their money has been retained by the company. And that is what Section 45 is saying, that as a general rule, where shares are issued by way of capitalization or bonus issue, no payment is required. Apart from that, when shares are issued, the shares should be issued for valuable consideration. In other words, value or some payment should be made to the company for the shares being issued. And again, in terms of the preferred mode of payment, cash is a preferred mode of payment. And that is why Section 45(1) will say that valuable considerations will be paid or payable to the company. And unless otherwise agreed, shares shall be paid for in cash. So the mandatory and default mode of paying for the value of the shares given you is cash, except that the law permits the company to enter into agreement with the shareholder in order to accept a non-cash payment. But then that agreement is also strictly regulated, as we'll see very soon in terms of Section 45, subsection 2. So let us keep that in mind. So the general rule is that payment for shares should be in cash. The exception is where an agreement has been made between the company and the member that some other form of payment should be accepted. But the agreement for accepting other form of payment must actually be in consonance with the strict prescription of Section 45(2), which stipulates, and I quote, where a company agrees to accept payment for shares otherwise than wholly in cash, the company shall, within 28 days after the allotment of the shares, deliver to the registrar for registration a contract in writing, duly stamped, evidencing the terms of the agreement and the true value of the consideration. Or if the agreement has not been reduced to writing, particulars in the prescribed form of the agreement, duly stamped, as if it were a written agreement. So what the takeaway from Section 45(2) is that it is permissible for an agreement to be made between the company and the shareholder to accept payment for the shares, not wholly or completely in cash. So part can be in cash and then part can be non-cash. However, as part of later on what we call the capital maintenance doctrine, in order to ensure that the fundamental principle underlying the issue of shares is not eroded or is not taken for granted, it is a requirement of the law that the agreement under which payment other than cash is going to be accepted must be registered with the registrar of companies, so that when there is winding up or liquidation, or there's any other investigation into the affairs of the company, we can establish whether the principle that value should be given for issue of shares was observed or not observed. Otherwise, you end up getting shares being issued as freebies and no value coming to the company. And people will be dealing business with the company thinking that the company is well capitalized, not knowing that the company is just an empty shell. And by the time people discover that, it will be too late. So there's a time limit where there have been allotment of the shares. Everything has been done for a particular person to be entered into the register of members as having been given shares. Within 28 days, information about the agreement or the agreement itself is supposed to be stamped and then delivered to the registrar of companies for registration, as it were. And I explained the rationale for the requirement that the agreement should be registered of the register of companies for you as a way of monitoring that, yes, if somebody provided service and in lieu of payment for the service, we are going to give shares with to that particular person. Okay, how much was the service worth? And for that matter, how many shares are being issued to the person? We should have the evidence. And I'd like to invite you to read the interesting case of Ozzy Air and Darko. Ozzy Air and Darko. Ozzy Air and Darko is a case that as in the last semester, when we're discussing in a contract involving companies, I invited you to look at. So I presume that all of you have read Ozzy and Darko. Let me just put the Ozzy. See if I get the space to, oh, sorry. If I get the space to write it for you. Okay, there's a space here. So Ozzy and Darko. Ozzy Limited versus Wood. So that is it. And the citation is 2005, 2006. 2006 Supreme Court of Ghana Law Report, page 1057. Well, I have mentioned that case just for you to appreciate the possibility of shares being issued not in return for cash, for service or some other things given to the company as it were. And just because we are friends, I'll tell you a little bit about the case before you go and read the full judgment. Mr. Kobna Darko, a businessman, the second defendant in this case, he spearheaded registration of an oxygen manufacturing company known as Aussie Air Limited. That's the first defendant company. Now, Mr. Kobna Darko, the second defendant, acting in his capacity as the managing director, an officer of this Aussie Air Limited, procured various forms of assistance from the plaintiff. Particularly the first plaintiff, in the execution of the objectives of the company. This included technical advice on the required voltage for running an oxygen plant, transfer of some money to the second defendant by the third plaintiff as deposit of an investment relationship. Deposit for investment relationship with the first defendant company, self-finance foreign travels by the first plaintiff to conduct pre-shipment inspection of the plant, assistance in the construction of the factory, building, and installation, and test running of the machinery. The first plaintiff also prepared a feasibility report for the Bank of Ghana in support for a foreign loan to the company. The plaintiff made all those contributions towards the setting up of the oxygen production business for the first defendant company. Upon an oral agreement reached with the second defendant that 40% of the shares in the first defendant company will be allocated to them, alleging that the defendant had failed to honor the promise on allocation of the shares to them, the plaintiff brought an action in the High Court for damages for breach of contract. The second defendant put up the argument denying ever making such a promise to give 40% shares. On the question of the payment made to the second defendant by the third plaintiff to be used to further the business of the company, the explanation given by the second defendant was that it was part payment of a loan and not as a payment for shares in the company. Now, the trial judge made a finding that there was on the evidence a valid agreement between the parties whereby the plaintiff rendered services and provided monies in expectation of allocation of them to 40% shares in the first defendant company. The High Court therefore held that the plaintiff had breached the agreement and were therefore entitled to compensation in the form of damages. So an appeal was made to the Court of Appeal, and the Court of Appeal agreed with the High Court decision. The defendants were dissatisfied. They are appealed the Court of Appeal decision to Supreme Court. And among other things, the Supreme Court held dismissing the appeal. In other words, the Supreme Court also agreed with the High Court and then the Court of Appeal. And the Supreme Court made various observations, but what is of interest to us in our present discussion is the possibility of the value of services being used, if you like, as a mode of payment for shares. But then, as we have discussed, in terms of in terms of section, let me clean the board. In terms of section 45(2), the details of the agreement should be registered with the Registrar of Companies. So please read the Aussie Limited and Darko against Wood. So just for avoidance of doubt, despite the fact that capitalization issue or bonus issue does not require payment to be made by the shareholders, that issue does not have to comply with the requirement under section 45(2) that where agreement is made to accept non-direct cash payment, then the agreement should be registered with the Registrar of Company. That does not apply to capitalization issue. So that is the effect of section 45(3). So let us keep that in mind. Now, section 45(4) is also very important. But just before we move on to 45(4), I would like you to do a slight adjustment to the law. If you look at the section 45(4), you notice that it makes reference to the Bodies Corporate Official Liquidations Law, Act 180. Now, as you are aware, this particular law has been repealed. It's been repealed. And in its place, we have the corporate. Now we have like the corporate, let me write it here, corporate insolvency and restructuring. The word restructuring, Act 2020, Act 1015. Yeah, so section 45(4) is to the effect that, quote, the statement in the agreement of the value of the non-cash consideration is sufficient evidence of the true value of the consideration. But when the company limited by share is in the course of being wound up under, as I said, don't say the Bodies Corporate Official Liquidation Act again. I will say when it's being wound up under the Corporate Insolvency and Restructuring Act 2020, Act 1015, the liquidator or creditor may apply to the court. And if the court is satisfied that the true value of the consideration was less than stated, it may direct that the shares shall be treated as unpaid to the amount of that money it shall direct. In other words, section 45(4) is telling us a bigger policy rationale for the insistence that where an agreement is made between the company and the shareholder, that shares will be issued to you. You don't have to do direct cash payment. you are going to do indirect or non-cash payment, that agreement should be registered with the Register of Companies. The idea is to enable an official or creditors who may be interested in knowing the true value and operating capital of the company, where the company is no longer a going concern and it comes to the crisis point, it's being folded up or liquidated. Now, when official is appointed or when creditors are so desirous, they can go to the Register of Companies, open the books and find out the agreement under which payment was accepted, not in cash form but in some other form, and it can cause valuation to be done in terms of how much value was put in the agreement vis-a-vis the number of shares that were issued. And then the prevailing price of shares at the time that the agreement was made would also be considered. If the number of shares, for example, given for whatever service or whatever thing given, the value of which is supposed to be like the payment for the shares, was, for example, woefully less than the true value of the number of shares which were issued to that shareholder, then when the necessary computation is done, the shortfall will be treated as unpaid value and the shareholder will be called upon to pay. So the idea of registering the agreement for non-cash payment is actually for purposes of monitoring to ensure that the company is not shortchanged, the creditors are not shortchanged, and true value is actually given by the shareholders, even if not in direct cash form. So let's keep that in mind. Okay, so we will discuss so before we discuss the return of issue, I would like us to jump to section 48 to say a few more words about what it means to pay for the shares in cash. So section 48(1) is to the effect that for purposes of this act, shares have not been paid for in cash, except to the extent that the company has actually received cash for the shares at the time of or subsequent to the agreement to the issue to issue the shares. So we are being given a litmus test for making a determination as whether the valuable consideration for issue of shares can be said to have been payment in cash. And what 48(1) is telling is that, yes, you are said to have paid for the shares in cash in one of two ways. Either at the time that the shares were issued, you gave direct money to the company, or after the shares have been issued, according to whatever agreement that you made, that whenever you are going to pay, you've actually paid according to that agreement. That is what it means to say that you have paid for the cash, for the shares in cash. So let's keep that in mind. And that is why section 48(2) will say that where shares are issued to a person who has sold or agreed to sell property or rendered or agreed to render service to the company or to person nominated by that person, the amount of money of payment made for the property or services shall be deducted from the amount of cash payment made for the shares, and only the balance shall be treated as having been paid for in cash for the shares, despite an exchange of check or any other securities for money. So we are being told that even if you've had some transactions with the company, shares are issued, yes, you have a property that you sold to the company, or you perform some service, okay? And then the company has to pay you. Now, the amount of money which has been paid by the company for the property that you have sold to the company, or the property that the company has sold to you, as the case may be, will not be treated as payment in cash, except the portion which you are giving to the company for that purpose. So let us keep that in mind. So just before I take the questions, let me discuss section 46 and 47, because we'll be drawing the curtain down here, and then I'll take the questions. We continue next time. Yeah, so where shares are issued, a report is supposed to be provided by the company to the Register of Companies. And that report is what we call return of issues. So section 46 says that where a company issues shares other than a reissue of treasury shares as defined in subsection 3 of section 61, the company shall within 28 days after the issue deliver to the registrar for registration a return in the prescribed form showing as at the date of the return the following information: the amount of stated capital attributable to each of the items specified in section 68, the number of the authorized shares of each class, total number of the issued shares of each class, the amount of money paid on the shares, distinguishing between the amount paid in cash and an amount paid otherwise than in cash, in the case of limited by shares, the amount of money remaining payable on the shares, distinguishing between the amount presently due for the payment and amount not yet due for payment, and the total number of the treasury shares of each class. In other words, all that section 46 is saying is that when the company has issued shares, has given out shares, within 28 days, or maximum period of, if you like, 4 weeks, the company is supposed to send a document, which is a form of like a report, providing a report on the state of affairs as far as the shares of the company are concerned to the Register of Company. And the information required to be provided are what we have in section 46. So the stated capital of the company, how many shares pertain to the various classes of shares, how many of the various classes of shares have actually been issued, and how much money has been paid, how much money is remained to be paid. If the payment was non-cash, what are the details? So all these particulars or information are supposed to be sent to the Register of Companies, so that at every point in time, we have transparency regarding the capital position of the company and its various structure. as it were. Now, finally, where these requirements are not fulfilled, maybe just before I talk about that, in section 46, we saw a certain concept, what we call the treasury shares. Later on, when we are discussing preference shares or preferential shares, we talk about the called redeemable preference shares, shares which are given out, and at some point in time, the company can take the shares back, or the shares may be taken by the company and the money paid to the shareholder. And when they are so taken back, we say that they have been redeemed and they can be reissued. So between when they are redeemed and then when they are reissued, we call them the treasury shares. So that is the meaning of the treasury shares referred to in section 46. Now, where the regulatory requirements under 45 and 46. 45 says that where you accept payment in the form of non-cash, you must register the details of the agreement within 28 days. You don't do that, you suffer penalties. And the penalties are what section 47 is providing. Again, within 28 days of issuing the shares, you are supposed to submit a report in the form of return of issues. If you don't do that, you also suffer penalties. And section 47 says that where there has been a default, as I have explained with respect to section 45 and 46, then the company as an entity and every officer of the company who is in default, that is, whose action or inaction is responsible for the company not complying with section 45 and 46, will suffer administrative penalty of 25 penalty units for each day during which the default continues. Good. So this will mark the end of our discussion for tonight.